speaker. Thank you, ma'am. We welcome you here on our board. And your mic is mute.
Thank you. Thank you, Nitesh.
So I request Hitakshi to give the brief introduction of ma'am.
Thank you. A very good afternoon to everybody, and I welcome everybody on the board today and our speaker, Mrs. Meghna ma'am, of course. Mrs. Meghna ma'am is a senior partner at Sankhla law firm, and she's a qualified lawyer having experience of more than 15 years into the field of litigation. She initially started her career in the year 2001 under the able guidance of her father, Shri S.P. Mittal, who has mentored her in various aspects of law. Over the period of time, Mrs. Meghna has gained expertise as an appellate lawyer and is a well-known face in the Supreme Court of India, Delhi High Court, NCLT, National Consumer Dispute Redressal Commission, and various other forums, which I may name DRT and DRAT as well. And Mrs. Meghna has also been one of the elected representatives in the executive committee of the Delhi High Court Bar Association in the year 2014. Mrs. Meghna has been extensively dealing in various facets of consumer law, for example, insurance, negligence, medical negligence, death claims, and other claims. She's also been the amicus curiae for the National Consumer Dispute Redressal Commission for several years. Meghna ma'am is an experienced lawyer having in-depth knowledge of law and the procedure there too. And ma'am, we are really proud to have you here on this very important topic today, which is the Consumer Protection Act, because it touches everybody's life. Everybody is a consumer at each point of time, I believe, because we're all buying something, we're all doing something or the other. So I'm really hopeful that I'll learn something today better. And over to you for the webinar. Thank you so much for sparing your time, ma'am.
Thank you so much, Disha. A lot of things have been said in the introduction, and you've added pressure to me by saying.
We cannot hear you, Hitakshi.
Me? Ma'am was speaking.
So over to you, Meghna ma'am. I think from here onwards, you take.
Right. So can you hear me? Am I audible?
Yes, ma'am. We all can hear you.
Perfect. Okay. And just give me a moment. There is some background noise which possibly could be avoided. All right. Nitesh, is the screen visible?
Yes, ma'am. It is.
Excellent. Since I cannot see any of you, I just thought that I'll just confirm with you.
We all can see you.
Good afternoon. Namaste, everybody. Thank you for being here today to listen to what I have to share as regards Consumer Protection Act. Let us discuss the brief reason why the Consumer Protection Act came into picture. Now, what happened was that for every redressal, consumers had to rush for civil litigation, which was an unending procedure with various formalities of court fees, of drafting, which a common man, a very basic consumer, would at times not even understand. Seeing such a plight, the legislators decided to enact what we call as the Consumer Protection Act to help these very strata of individuals who would not understand the basic crux of courts or the procedures therein, the formal procedures. So the name of the act is the essence of the act itself, to protect an ordinary consumer, an ordinary person. What the act envisaged was to lessen 4 things: paperwork, the formality involved, the expenses that are entailed in a general litigation, and also delays. The act envisaged quick redressal, And you could even probably format your complaint on a plain piece of paper and present it to the presiding officer, and you would have a right to be heard, and you were heard, and your complaint was redressed. Now, this was basically to let the common man feel secure and let the whole idea of being answerable, the manufacturer being answerable or the seller being answerable was brought into picture. The Consumer Protection Act 1986 was enacted, and then thereafter it was amended time and again, depending on the need of the hour. The last being in 2002. I'm not coming to the 19 Act immediately, because what the 19 Act would do is completely repeal the old Act. So as backdated as 2002 is when the Act was amended by increasing the jurisdiction, the pecuniary jurisdiction, adding on to the definition of unfair trade practices, and so on and so forth. However, we come to the modern day age, that is today. What happens today? We are in a situation where we are exposed to various kinds of options, various kinds of online, offline options. So where does a consumer go? Seeing all of this, the new act, which is the Consumer Protection Act of 2019, that has been enacted to enable us to take advantage of the act in today's date. So I was going through the preamble of the act. That's the general pattern I follow. So I read the preamble of the 86 Act and then the preamble of the new act. So permit me to read it out for you. So the preamble of the 86 Act read, an act to provide for better protection of the interests of consumers, and for that purpose, make provisions for the establishment of consumer councils, other authorities, for the settlement of consumer disputes and matters connected therein. So we see the prime purpose of the 1986 Act was better protection of consumers. So while we are already protected under the law of the land, but the Act crystally only protected the consumers, and it was only dedicated to consumers and nobody else. The 2019, the preamble to the Act reads, an Act to provide for better protection of the interests of consumers, and for that purpose, to provide authorities for timely and effective administration and settlement of consumer disputes and matters connected thereto and incidental. Now, this brings us to the essence of the new Act. The very words of the preamble give us the aim of the Act. The aim is timely redressal without delay. What they have done is that we will provide speedy redressal to all the consumers. And there are various provisions which have been enacted, which I shall be discussing. Basically, the old Act is now about 33 years old, including all its amendments. So obviously, we need to change the Act as per the times. Why? Because now we have introduced e-commerce. What is e-commerce? Online purchases. We have more platforms, we have more sources, we can buy from different sources. We don't even have to step out of the comfort of our homes and buy anything. So how are those purchases protected? They are protected by the new Act, that is the Consumer Protection Act of 2019. What the Act does is provide us specific rights. I hope you can see the little PPTs that we've made for you.
Yes, ma'am, we can see.
Wonderful. So here are the rights. All the consumers have certain rights. Right to safety, right to be informed, right to choose, right to be heard, right of redressal, and right to consumer education. All these are the rights of a consumer. When we are buying a particular good or we are availing a particular service, we have the right to be informed, to be protected against unreasonable marketing or wrong marketing, wrong claims, We have a right to be informed about the kind of goods available, what do the goods entail in them, what are the specialities of those goods, what are the options available, right to choose which product we want to buy, right to be heard in case something is wrong. Where do we go? Where do we go for redressal? Do we have to rush to courts every time? Is there another forum where we can go and approach and get a far more speedier redressal? And then to consumer education. You must know that you are protected. So every consumer, by way of right, has to be informed that he has a right to approach court if something goes wrong. So all these are the rights which we enjoy as consumers. Let us come back to the format of the Act. The Act, how it defines who is a complainant. Let us see who is a complainant. A consumer, a voluntary organization. Has my video gone by any chance? Hello?
Yes, ma'am, you are not visible.
Yeah, there was absolutely, it got stuck. Let me see if I can.
Ma'am, can you put a screen a little bit upward? Your head is cut, you know, like. Yeah, now it's okay. Good.
Now
Thank you, ma'am. Yes.
Perfect. So who is a complainant as per the Act? The new Act, besides recognizing the earlier complainants, that is A, a consumer, B, the voluntary consumer association, the central government, state government, or in cases of one or more consumers, then a person can simply go and represent, also recognizes the existence of a central authority. I will be discussing that. A specific chapter has been dedicated to the central authority in the new Act, and also recognizes the existence of a minor as a complainant. If you all will recollect, there was a famous case of the Spring Meadows Hospital. This case crystallized and recognized for the first time the existence of a minor being a consumer. The minor was recognized as an independent consumer. He can be represented in court through his parents, and that was the first landmark judgment where minor was recognized. The new Act has formalized this by including it in the definition of the complainant itself. So now we have these categories which are displayed before you on the screen as well for easy reference. Very well. Then we come to a very pertinent definition. The definition is who? Who is a consumer? A consumer, by the definition or by the very name of it, is the person who buys goods and services in exchange for a consideration. So this is a very simple definition. Who is a consumer? Black's dictionary describes it as a consumer as a person who consumes. Very, very simple, not very complicated. But what are the key aspects? What are the points which fall in the realm of being a consumer, which is recognized by the courts? When do courts recognize that, yes, this person is a consumer? So the first very important aspect is consideration. That is, when you purchase something, unless money is involved in the transaction, you will not be treated as a consumer. Now that money needn't be given at one go. It could be a promise to pay. It could be an advance payment. That the mode doesn't matter. There has to be a consideration of towards the transaction to let you be recognized in the category of a consumer by a consumer court. Secondly, you should buy a good or a service. Now, what are goods and services? Goods, by the very definition, are anything which are objects, and it has been defined. The only new thing that the Act does is this time it recognizes food also as a part of being a good. This is more so because now there has been an advent of something that we call food delivery platforms. We only are not going to restaurants, food is also being delivered. That has been the motive of including food as goods. Then service. What is service? Service is one who hires or avails any service or services for a consideration. Again, the key word is consideration. But in service, there are two kinds of services: contract of service and contract for service. That is a thin line of distinction between the two, and the courts recognize for the purposes of being a consumer contract for service. I'll just come to it. That Nitesh had told me to let all of you know a few judgments so that it becomes easy for reference. So the key judgment for who is a consumer could be the Lucknow Development Authority versus M.K. Gupta. This is in 1994, 1 SCC 243, which has an extensive discussion on who is a consumer. A very, very recent judgment of Canara Bank versus United India Insurance, this is sometime in March this year by the Honorable Supreme Court, where the Supreme Court has reiterated that the aspect is a consumer includes people who hire and avail services for a consideration, not only them, but those who are directly benefiting from that service. Now, this becomes very crucial, especially in insurance cases. Why in insurance cases? The example would be, for example, when you take a life insurance and the person passes away. Obviously, the insurance is activated only upon the passing away of the person. So, the insurance, the beneficiaries file a claim, and that claim gets rejected. There is a grievance. There is a dispute between the insurance company and the beneficiary. Now, by virtue of this aspect of the beneficiary being entitled to approach the consumer forum, the beneficiary of this policy is entitled to approach the consumer forum as if it was the insured himself in his absence, obviously, since it was a life insurance, and approach the court seeking redressal that, look, we had taken up, my husband or my father had taken a policy. Now, after his death, the company is not honoring it. And then the courts will see, and the legal course, of course, will decide the reason and whether the beneficiary is ultimately entitled or not. Another very important case also, which I came across, it is also a very recent case of this year itself, when the courts were functioning. Dr. Chandrachud had decided it. It is the Joint Labour Commissioner and Registering Officer versus Kesar Lal. The question under consideration was whether a construction worker registered under a statutory act is a beneficiary of the scheme made under the rules pursuant to the act, whether he is a consumer. Now, what the judges decided was that I will read out the lines. Public accountability is a significant consideration underlying the provisions of the Consumer Protection Act. It's very beautiful. The evolution of jurisprudence in relation to the enactment reflects need to ensure a sense of public accountability by allowing consumers a redressal in the context of non-sovereign functions which are not rendered free of charge. You may kindly go through this judgment. I can give you the citation, which will give you a very broad perspective of who's a consumer and how the courts have decided when somebody is, again, even against a statutory body. It is 2020 SCC Online, Supreme Court 327. Joint Labour Commissioner versus Kesar Lal. So, having discussed who is a consumer, maybe we could proceed to what is a service, because we've been discussing goods and services. What is a service? A service is anything which is intangible. You cannot feel it by your hands, but it is provided to you. A very important aspect again is that the service which has provided to you should not be provided free and should not be under a contract of service. Now, what is a contract of service? The classic example is an employer and an employee. An employee is under the contract of service and he's acting on behalf of the employer, and he will not be held liable. And for service, a very important case, the VP Shanta case. I'm sure everybody's already aware of this. It says that that was the case which brought professionals under the realm of the Consumer Protection Act, and held that the services rendered by a medical professional, by a medical practitioner towards his patients, fall under the definition of services. That is, that it was argued there that, you know, that a doctor, it's a contract of service, but it was rejected, this proposition, and said that it is not a master-servant relationship, or we are not under any employment of any sorts. A doctor is only providing a service for a particular aspect of the for the patient, for redressal of his ailment, and thus it will be covered under the Consumer Protection Act. What is then deficiency of service? It's very simple. Anything which is faulty, which is inadequate, there is some shortcoming in the service, in the way in which it should have been provided, that manner has been deviated from. One has to prove that there is deficiency of service because he was supposed to provide this particular service in a A, B, C manner, and he has deviated and gone to D, E, F. And there is no logical, plausible explanation. When there is no such logical or plausible explanation, it is considered as deficiency of service, which is redressed by the consumer forums. Now, damages could be anything. There could be physical damages to property. It could be damage, emotional damage, mental stress. That's all we generally claim in the consumer forums. Agony, mental stress, trauma, all this is covered under the said term. The new act has also brought forth something very interesting, which is product liability. What is product liability? Being liable for the product that you are selling. It's very, very simple. It is the responsibility of a product manufacturer or the product seller for any product or service to compensate for any harm caused to such a consumer by defective product manufactured or sold by deficiency in services. Now, what exactly why has this been brought? It's obvious because of the introduction of e-commerce. There are various platforms like Amazon, like Flipkart, like Snapdeal. They are providing us services, but they are not liable for it. To make these very liable to their actions, to what they sell, is product liability introduced as a specific chapter, Chapter 6 of the Consumer Protection Act, which completely deals with product liability. Sections 82 to 87 are completely devoted to this aspect of the new consumer law. And it is an action which can be brought in either of the forums, the District Commission, the State Commission, or the National Commission, and the manufacturer will have to compensate you for the harm that he has done to you. What is harm? Incidentally, the Act also defines what is harm. It includes any injury, bodily, it includes death, includes illness, includes damage to your property. It also includes emotional distress. So any of this, any harm caused to a consumer by a manufacturer's product, he is liable to be booked in the consumer court, and he is liable to the consumer for his inaction. Now, what are the bases of an action? When would be the situation when a manufacturer becomes liable for the product? It's very simple. When there is definitely a manufacturing defect. The product says something, it performs in a particular manner that is absolutely tangential to what he's claiming, or has a defective design, deviations from specifications of manufacturing, or it does not conform to the warranties provided, or it does not contain adequate instructions so that it guides the consumer to be able to use that product in a particular manner. So if those specifications are not given, then he is liable. The manufacturer becomes liable under this section of product liability specifically, and the consumer can go to court and avail redressal, stating that this manufacturer has promised me this, given me this, it's tangential, please provide me relief. Now, we come to the aspect of product seller. Who is the product seller? Like we just said, the person who is being able to sell you the goods. How come he is responsible? He is not manufacturing it. How do we bring him in the realms? There are conditions enlisted in the Act which make a seller liable along with the manufacturer, and at times only the seller liable if the conditions are such. A seller would be liable in the following situations. One, where he has substantial control over the designing, the manufacturing, the packaging, the labeling of the product. Second, so this is a very self-explanatory thing, I don't think. The identity of the manufacturer is not known, or we cannot even effect our service of the damaged good or the deficient service, deficient good to him. What happens? Who do we nail? We can nail the seller under this Act. It's very important when we access goods through platforms like Amazon, through Flipkart, all these, it comes very handy. This section will prove to be very handy at that time. And also in case when there is an express warranty made by the manufacturer and the seller, he endorses that. He also portrays to you as a consumer that yes, this good is exactly what the manufacturer said. Whatever is written in the box, it's absolutely true, but it does not end up being true. So in that situation, we can also make the seller liable for making such tall claims. Also, there could be a situation where he has altered the product in some manner, which has created that defect. Maybe the manufacturer had sold him in a particular form, but he in his own sensibilities decides to alter it, which causes the product not to function in a manner in which it is meant to function. Then also we can hold the product seller liable. Then he becomes liable under this Act. And also, there are at times the seller is liable to tell us as consumers that a product is supposed to be used in this particular manner. You will have to use these very specifications. In this manner, you will have to assemble it or consume it. If you do not share this particular information, which you are bound to share with a consumer, then also you are bound, you come under the realm of a complaint having been filed against you and under this section of the Act. Very interestingly, what the Act under product liability would also cover is celebrities who are often endorsing different kind of products, at times creams, at times shampoos, at times buildings, builder houses, and this is all endorsed by them without, till date, they do not have any liability whatsoever for such advertisement. Now what the Act does, it makes them liable. There is a fine that covers if in case they are giving us misleading information. Why? Because celebrities have an impact on us. When we look at the television and a celebrity is endorsing a particular product, our mind will gather that information and say, yes, if he is using it, so can I. And if it has helped him, it will help me. So they have the power to sell. They have the power to engage the consumer, make them believe that yes, the product is what it claims to be. And in such a situation, if the product turns out not to be what the celebrity has claimed, the person who is advertising, he is also liable under this Act, and he can be fined up to 10 lakhs. He can also be prohibited from ever advertising another product. I was also reading, while I was preparing for this note, I was reading the laws of USA and Singapore regarding celebrity endorsement. And in fact, it is a specific crime over there, and they are very, very serious. In fact, companies which advertise falsely are stopped completely. Their functioning is absolutely stopped in courts. I mean, from manufacturing. So that was pretty interesting. And I don't know, I think it's a welcome thing. Celebrities should not endorse anything unless they themselves have tried it or they are a part of it. Unless they test something, only then They have the right to influence our minds in the way they do. And in India specifically, they have a lot of weight in our eyes, I'm sure. I'm sure all of you agree with that. So while the Act is so benevolent about bringing product liability and bringing the sellers, there are also loopholes. And there are also a customer's duty to the product before he can run to court shouting foul. So the customer should not have acted in a negligent manner in dealing with the product. He should have used it as per the specifications of the product. Also, he should not have used it under influence of alcohol or any drug which has not been prescribed to him by a RMP. So all these are loopholes. So which one, once this Act comes into practicality and starts, having a day-to-day use, is when we'll get to know about how this functions. However, the aim is definitely to bring the product manufacturer or the product seller, whichever platform, wherever it is, liable under the Act. The Act, furthermore, also introduces an aspect of an unfair contract. Now, what is an unfair contract? The very name defines it. Unfair, which is unreasonable, which is unilateral. Often you would have noticed that certain manufacturers or certain traders or services that we have, they are backed with unreasonable conditions. For example, if you want something, there is a huge security deposit which you have to pay. Or if you avail a loan from a bank, they will say, no, you cannot repay it. You cannot repay it in full, or there'll be extra interest, or there'll be a penalty if you repay the loan in a particular manner. So all these are unilateral conditions which a consumer has no option but to adhere to, because he is not in a position of advantage over there. The person who is dictating, the consumer often signs. Even if we go and avail a loan, we sign those papers. All right, we will not repay. But what tomorrow if a consumer really wants to go and pay off his loan? Should he not have the right to do so? So this aspect of the new Act covers such contracts. It's also mentioned here on the screen that contractual terms which specify excessive security deposit provide for unilateral termination or assignment without consent of other party, amongst several other grounds. So various such grounds are enlisted in the Act, which also brings unfair contract to be a part of the Consumer Protection Act. Now, what is interesting is that if you are going to court for an unfair contract under the terms of unfair contract, you can only approach the State Commission or the National Commission. And you have no, District Commission has no jurisdiction over such cases based on unfair contracts. The Act also has widened the definition of unfair trade practices to include misleading advertisements, to include an act of the seller not issuing the bill or refusing to refund the price of a defective good or making very delayed refunds. All these various aspects are also covered under unfair trade practices, and you can approach courts for the same as well. A very interesting formulation in this, if you remember, I had mentioned that who is a complainant includes a central authority. So there is a chapter dedicated to Central Consumer Protection Authority in the new Act. This is more like a regulatory forum where it has a lot of leeway, it has a lot of powers that it will enjoy. It's like a forum which will keep check any foul that it will protect, promote, and enforce the consumer rights. It will prevent violation of consumer rights. It will also see that there are no false or misleading advertisements by any company for any product, and that It will also keep a check on people who are advertising any product in a wrong manner or misleading the public by such advertisements. Now this forum can suo motu take an action against if it comes to know of any kind of misdoing, or it can take an action upon a person's complaint, or even the central government can write to it to take cognizance of such an issue. Having done so, it will pass an order. And in case you are aggrieved by that order, you are free to approach the National Commission. Obviously, since the Act is still not into play, we really don't know how much this Act authority would really be successful or how it will function. But at least there is an effort made towards such a formulation of a central authority. This authority is also considered a complainant, and it can on its own take an action in the consumer court, and including all the rights which it feels have got violated, or the reasons as I have mentioned, and they are shown in the screen above. So finally, we come to what the Act does in terms of the commissions. It has changed a lot in terms of the jurisdiction, in terms of the territorial jurisdiction, and in terms of pecuniary jurisdiction. Now, if you all recollect, the territorial jurisdiction of filing a complaint was only where the opposite party resided or worked for gain. By this Act of 2019, the territorial jurisdiction has also included person. The place of suing can also be where the consumer is residing or he is working for gain. So this will ease out things for a lot of consumers who at times did not take any action simply because they would have had to travel to the place of where the opposite party was or where they resided, and it was more inconvenient. So I think this will encourage more litigation, and more and more people will know their rights and would move forward for redressal. So this is one change for territorial jurisdiction. However, in pecuniary jurisdiction, there has been a massive change. So the district commission now enjoys the jurisdiction of 1 crore rupees, which was 25 lakhs as per the old Act. I'll call it old Act now, though still it's in force. The state commission has increased its jurisdiction from 1 crore to 10 crore of rupees, and thereafter the national commission, that is goods exceeding 10 crore. There has been a very important change in calculating the jurisdiction. So what generally our norm used to be, to avoid going to the state commission because it was more inconvenient for many of us to approach the state commission or the district commission, we would enhance the jurisdiction by adding a lot of claims otherwise, damage, emotional damage, harassment, and does inflate our claims. This has completely been done away with. Now the jurisdiction would be decided on the value of the consideration paid and not on what you're claiming. You may be claiming X, Y, Z, but if you have paid X for the good or the service, you will approach the jurisdiction accordingly. So if you have paid about 20 lakhs of rupees, or even if you have paid 80 lakhs, you can only approach the district commission. If your grievance is worth 80 lakhs, it will be, your grievance is equivalent to only what you have actually paid and not beyond that, not what you have claimed. So this will obviously bring down a lot of inflated claims, and people will be more reasonable about asking and then at the end of the day getting what they want. This brings us to another. So filing of a complaint. The new Act also introduces a very interesting aspect of e-filing of complaints. You can now file a complaint electronically. A nominal fee obviously has to be paid. That is, even if you file otherwise, you are supposed to pay a fee. And what the new Act stresses on is, once you file a complaint, it will make all efforts to, though the old Act also had this stipulation, but it has not been followed till date, that it has to at least decide upon the admissibility of the complaint within 21 days. The new act, under the new act, if the complaint is not decided in 21 days, it would be deemed to at least be admitted. So we'll be at least a step ahead in terms of speedy redressal on that front. The act also envisages mediation, the new act. So in case two parties are willing to solve their matter by talking and by mediation, then they will provide in a written consent to the court, and the court will give it for reference to the mediation cell, which will be formed by the respective state government or the central government, and then give a chance to parties to go and get their matter redressed. I hope I have not exceeded the time. Nitesh?
No, ma'am. It's well within time, ma'am. Well within.
Fair enough. Thank you. So, after having your complaint, what happens in case you lose your complaint that you have filed? Now, unless you have lost it because it is dismissed in default, or it is dismissed for non-prosecution, then you can go to the court, same court, for the same cause of action. This was decided in the case of Indian Machinery Company versus Ansal Housing and Construction Limited in 2016. However, what happens when you lose the case on its merits? Then the only option we have is appeal. So this chart will show you where you are supposed to go in appeal. From an order of the central authority, as I discussed earlier, the appeal is only available at the National Commission. From the District Commission, you go to the State Commission. From the State Commission's order, you go to the National Commission. And if it's the National Commission deciding your case, you approach the Supreme Court. And that is how you appeal in the Consumer Court. There is an option of review in case there is some error apparent on the face of the judgment. And then this act, earlier it was only the National Commission who could review its decisions. This act empowers the district commissions as well as the state commissions to review the decision. The power of revision still lies with the state commission and the National Commission for against any order which is passed in excess of jurisdiction, or there is a material irregularity. You can definitely go and get your redressal before the National Commission or the State Commission, as the case may be. So I guess, yeah, I think I have covered most of the points. As I say, it is no longer the era of caveat emptor. You are no longer to be beware. It is the manufacturer, it is the seller. They better beware. The caveat emptor maxim now is absolutely obsolete, and this act completely makes it lose its significance in terms of the Consumer Act. Thank you very much. I think I have covered mostly everything. If anything is left, we can discuss it. Or, yeah, I cannot see any of you though. I would love to see some face.
So Priyanka, now I request you to take the questions one by one, which are there on the chat box.
Nitesh, is it possible? I see people. I cannot see anybody. I'm talking to my own self apparently.
No. There are people are already there. Actually, during the session, there is a norm that
I appreciate that. Now let me see a few people. At least I'll be able to talk to somebody.
We are all there. Don't worry.
Oh, I'm sure they're all there. Thank you. How sweet.
So I request everyone to have their camera on, not the mics on, so otherwise it would be so disturbing. So to show ma'am that we all are here.
No, I want to speak to people. That's about it.
Yeah.
So thank you, ma'am, for such an enlightening session and honoring us with your presence. Now our viewers have been putting up questions which I like to put forward. So the first question is by Advocate Zoya Mehta. She's asking that how can the deficiency of service be proved in a medical negligence case when the subject matter of these cases happens to be technical in nature?
In what way? Subject matter, Zoya, I can see you. Hi. Now, medical negligence is a very tricky situation, Zoya. Obviously, I'm sure you are dealing with such cases. That's why you are asking me. And I personally have dealt with a few questions, and it becomes very difficult to maybe prove.
We cannot hear you properly.
You cannot hear me properly?
I can.
Now it's okay.
Zoya, आपको सुनाई दे रहा है?
Yes, ma'am.
Perfect.
Definitely. Yeah.
So your question is, how do you, so there are certain, the judgment of VP Shanta, for example, and there's a Jacob Matthew judgment, which shows the entire manner in which the negligence of the doctor has to be shown. It should be very categoric that he has not exercised reasonable care, that he has not acted in a manner which a prudent doctor or a prudent person would have acted had he been in his place. So there is a realm in which you treat a particular person. You can obviously go wrong. That is very human. But that you should not go wrong because of a negligence which is so irrational or so unreasonable that has caused harm. Even the Spring Meadows case, you can probably refer to that case also, which can enlighten you on these. You have to probably, do a detailed study of various cases and then put your own case in the light of these judgments and see whether it fits there. There are boards which are constituted, who see and advise, and it's not as if it's always pro doctors. The benches are very pro consumers, and they very strictly and in a very tight regime, read these cases and act on them. There are boards formed. Those boards go through the reports. One thing is, you must keep the entire report and all the paperwork with you in a very, very crystal clear format. You must not miss a single paper. Because if you have to prove negligence, how will negligence be proven? I'm just talking about the practical aspects. The patient will have to have all records. God forbid, if the patient is no more, then his family needs to have all records on what happened from day one and what was the course of treatment, so that the judges and the panel, which is constituted to see if the doctor was negligent at the end or not, will be able to decipher correctly and will be able to pinpoint that, yes, this is not what a prudent person would have done. This is negligence beyond, what it should be.
Yes, thank you.
Yes, Priyanka.
Thank you, ma'am. The next question is again by Advocate Zoya Mehta. She's asking that, is mediation compulsory in all matters or is it optional?
No, it is not compulsory. In case you feel, then you'll be able to give a written consent, both the parties. Upon such an application, the courts will refer you to mediation.
Okay.
So it's not at all compulsory.
Thank you so much.
I'm sure when judges will say,
I think it makes sense for make all these things compulsory when it is civil litigation. It makes sense because
you see, Zoya, again, it becomes situational.
Yeah.
It will become situational on what the
Yes.
consumer wants. Who is on the opposite end? Is he a reasonable person? Is he, what he's asking, what the consumer is asking, if that is reasonable, or maybe what the other side. At times, the opposite sides are big wogs, but you can't even face them in court. They have such great representations. Ideally, Consumer Protection Act was, formed with the idea that the consumer can straight away go to court without any hassle. He can write on a piece of paper his grievance and it will be entertained. You don't need lawyers. But the situation in practicality is so different. Now consumer courts are as intimidating as any other court. You have to, you need your lawyer. You cannot go without your lawyer. You need a proper formatted representation. Even though the book is saying something else, the act is saying, but the practical situation we all know is so different. It's completely different. I mean, I personally feel, I have myself seen the NCDRC change from what to what. Earlier, we would actually literally be having interactions with the judges in a very, very friendly atmosphere. Now it is very strict, in a very formal, interactions do happen still, but not the way we used to have happen when the act was initially initiated, and those earlier forums used to be different. I'm sure, Zoya, you feel the same.
Yes, I've been there once, ma'am. I have one case, NCDRC case, and then that's the reason. And it's a medical negligence case. So that's why I asked the question. Yes, ma'am.
If you need any help, let me know. Don't worry.
Definitely, ma'am.
Apart from
Thank
this
you so much.
call also, I can help you.
Thank you so much, ma'am.
No problem.
Thank you so much, ma'am. The next question is by Nitesh, sir. He's asking that, can you throw some light on the procedure of execution?
Execution. All right. Yes, of course, I can throw a lot of light on it, but I think it will need a full devotion. So what this act has done is, in fact, it has increased it has brought penal action into play, but it has also got compounding of the offenses. And that's a little more detailed discussion, my dear Nitesh.
Actually, the question is by Mrs. Nitesh Mehra.
Mrs.
So,
Nitesh is smiling away to glory, I
so
guess.
she logged in by my name and then confusing everyone.
No, ma'am. The only specific query, if I can make it, is that just like in any other decree which we obtain under CPC, we can execute it where the defendant resides or wherever is the
Under the
defendant.
new court, under the new act, yes.
In this also, it is the same, or it is
It is the same in this new act. It was as if the decree was made by a civil court, and then there have been penalties which have been increased. But honestly, again, in reality, the picture is very different.
That what the book says is the same.
Book is very beautiful, very crystal clear, and everything is happy.
All right, very well. Thank you so much.
Thank you so much, ma'am, for the answer. I think that's all questions for today. And thank you so much, ma'am, for guiding us
Priyanka,
with your experience.
there are some questions by Shobhit. Kindly see. Shobhit, if you would like your question, want to take your questions with the ma'am, you can take up directly. Shobhit.
Yes.
Ji Shobhit ji, namaste. I can't.
Network issue.
Shobhit, no, Shobhit is muted by himself. Shobhit, you are mute, I think.
Good afternoon, ma'am. Good afternoon, sir. Namaste, ma'am.
Namaste.
Can you hear me, ma'am?
बिल्कुल थोड़ा कट कट के आ रही है, but I can hear you, Shobhit. आप बोलिए.
Ma'am, ma'am, the question number 1 is, ma'am, if the builder is not giving possession of the flat or returning the money, if the builder is not giving the possession of the flat, ma'am, and also not returning the money, can the consumer file a consumer complaint or the RERA complaint? Which complaint the consumer should file, or both forum can be approached by the?
Both forums can be approached, but now the RERA Act has taken over. Now you have to go to RERA. You will have to approach.
Okay, ma'am.
RERA, yes. And it is fast redressal there.
And ma'am, another question, sir, can I?
Ma'am,
Go ahead.
Voice is breaking.
Hello. Hello, can I ask you a question, ma'am?
हाँ, आप क्वेश्चन पूछिए. आपकी आवाज बीच में बहुत कट गई थी. अभी थोड़ी सी फिर से आने लगी. आप पूछिए.
Ma'am, and the second question is, the consumer purchased the car, for example, and after a few months the car start giving problems to the consumer. Then the generally practice is we file a case against the car manufacturer, the dealer, and the insurance company. Ma'am, but later on, if the car is not exchanged by the dealer, ma'am, what is the remedy left for the consumer in that matter, ma'am?
Court will decide whether you will get the relief will be car exchange or whether it will be car repair. That is what if you have already approached the forum, then the forum will decide. फिर उसके order क्या होता है, if it's acceptable to you, then we'll see. Otherwise, if you want to go in appeal, if you really want, I've done a case like this. So he
okay, ma'am.
He wanted exchange. Ultimately, they gave him a new car, but this is like very old case.
Ma'am, can I ask a question? Since Shobhit ji had asked a question on RERA and confusion regarding RERA and Consumer Protection Act, something like this, that the RERA Act was passed in a certain year. So is it a prospective law, and the builders who
RERA is, no, it can't be retrospective.
Yeah. So the builders who had given out their projects before the RERA Act would go under the Consumer Protection Act.
No. Your redressal will be under RERA. No, now they're all compulsorily registered there. If they're not registered, that is an offense in its own right.
All right.
That's a topic.
Okay, ma'am.
Yes.
Ma'am, we are looking forward. Ma'am, we'll request Nitesh sir to. Okay.
Say, come on. I don't want to interrupt you in between. Shobhit.
No, sorry, sir. No, it's okay, sir. No, it's okay.
Don't be sorry. It's an open forum.
Okay. No, just say, ma'am, we request Nitesh sir to have another webinar on RERA, if it is possible for you, ma'am. We can.
You're all sitting so well these days.
We are having this blessing in disguise, even we are sitting Vela, we are doing something productive, for all of us.
Exactly, ma'am.
In the long run. So, ma'am, I have 2-3 questions. One of them is it's a situation based. What if like this, nowadays these mediclaim companies, they say it's a cashless, and in most of the cases, they then reject the claim, stating that there have been something there in the patient's history, and even after paying 2-3 installments of them, they do not give the cashless. So, do they are also covered under the category of deficiency of service?
Yes, absolutely. You'll have to approach the insurance ombudsman. There is an internal arrangement also. Every insurance company has that kind of arrangement. Then the ombudsman might reject it, and then you can go with that rejection letter. You can very well approach the consumer forum. Only problem is you have to go to the district forum. That is one problem.
Yes, that's there. We have seen the cases pending long, Palotra.
I used to run away from district forums. I hardly ever went there, and I can see me going there a lot now. Okay, forget it. Let's not even go there.
Another thing is, ma'am, the first judgment which you cited, Canara Bank versus United India Assurance, was with regards to.
Okay.
Yeah, of that, can we have the citation? Because we just missed the citation of that.
अच्छा साहब, एक मिनट दीजिए मुझे वापस जाना पड़ेगा वो गली जो मैं छोड़ आई.
Or we can have all the citations together from you. We can put it on the group.
Sure, I can do that. I think वो मैं कर.
Ma'am, KC Lal citation also, ma'am, and Shanta case citation if it is possible.
हाँ, VP Shanta भी दे देंगे. No problem.
And ma'am, another point which I noted, this celebrity should not endorse anything. Is any specific judgment on that also?
Because ये law ही अभी introduce हुआ है, ये aspect ही अभी introduce हुआ है, अब आएगा, मजा आएगा.
We want that you should be advocate in that.
Ma'am, regarding this, can I speak? Can I ask?
Yes, sir.
Ma'am, regarding these celebrities, now how do we define, like a celebrity are those who are maybe actors, but there are a lot of people who are advertising the products who are not celebrities. So how would we, draw the line that which are celebrities and who are not celebrities?
That's the practical aspect. That's what we have to do. Celebrity, in our case, we generally able to influence the now sample Virat Kohli or Amitabh Bachchan. They will be very convincing, if they are selling anything from chai patti to a house, they'll be so convincing that okay, if Shah Rukh Khan is promoting this builder has to, because Shah Rukh Khan is endorsing this builder. And if Amitabh Bachchan is endorsing a tail, that will have wonderful effect. Look at his own hair. So, so anything, those are celebrities. But yes, obviously a first-time model will not be able to be considered. That is a profession. But, when you generally see a celebrity endorsing a product, there is a value of product that the celebrity enhances. And when you see, and automatically it comes in, Virat Kohli kar raha hai uska advertisement. Amitabh Bachchan bech raha hai, theek hi hoga. That kind of mindset. So that is a practical issue, which when, there will be some issues and then it will come, the law will become clearer. But it is interesting. I'm looking forward to this.
Yeah.
We'll soon see that Amitabh Bachchan is now selling a namkeen. That namkeen is not a moon namkeen or crunchy.
So the thanda cool tail is not cooling the head anymore.
So yeah, I think you have to definitely go ahead with that.
I have a question, ma'am. Can
who is this? I'm so sorry, I can't see you, or the connection is really bad.
Ma'am, it's me, Hitakshi, ma'am.
Anji, Hitakshi, boliye.
Ma'am, I just want to know that whatever these judgments are following from the State Commission or National Commission, are they also applicable to the online portals which are selling the goods? Because in practicality, there is a judgment in place that you cannot, even in your discounted items, after putting the discount on, you cannot charge any kind of tax, but online portals are still doing that. So is there any guideline on
this act will start. It will take a while for them, but yes, precedents will be binding. They're always binding on new acts. Maybe it may not be the same situation, but we'll be able to cite them and bring them. Maybe till now they were not, but now they will be liable. They will be more cautious. आप देखिएगा, once this act comes into practicality, these forums will also become more intelligent, and they will have these disclaimers. ऐसा नहीं होगा, you know, they're going to we can it's not going to be that easy, but then it is there. At least there's a law, and if not out of 10, at least out of 5, we'll find success.
Thank you.
Can I now request Komal to come and thank ma'am for this wonderful webinar? Komal, yes.
Thank you so much, ma'am, for an incredible webinar. It was truly an informative and articulative session. Teaching about this topic was an eye-opener to us. Learning new perspectives allow us to gain an insight about the laws and the norms of the Consumer Protection Act and its amendments. And during these hard times, we can only learn via digital platform. So it was a good initiative and the best way to bring everybody closer, share a common platform, and gain as much as we can from such an experienced mentor like you, ma'am. Thank you once again for an excellent webinar session, Meghna ma'am. And at last, I would like to thank all of viewers who took a time to attend the webinar session. Thank you. Over to you, Nitesh, sir.
No, I also have to thank Nitesh for this wonderful.
Ma'am, having you on the board is, you know, ma'am, we cannot hear you.
Ma'am, your voice is not clear.
My voice is not clear.
Your voice is not clear.
We'll mute ourselves.
I wanted to take this opportunity to thank the opportunity. Such morning. Can you hear me now?
Yes, ma'am.
Yes, ma'am.
Yes, ma'am.
Priyanka, thank you, Komal, for this wonderful vote of thanks, and thank you, Hitesha, Rohit, and Zoya for asking lovely questions. And last and not the least, my office team, Vitika, Kanupriya,
Thank you, ma'am.
Vaishnavi, they helped me prepare the slides. We were up till a little late last evening. It was a Sunday, and they didn't bat an eyelid, and they kept changing the slides the way I wanted to. I really want to thank them. If they can listen to me, if they're listening to me here, if they're here, thank you very much, girls.
Yes, ma'am. I can listen to you. So we were really happy to help you any day.
Thank you, my dear. And thank you, Nitesh, really. And Naginder to have suggested my name to you.
Yeah, ma'am, I just, you know, wanting to complete, you have, I think, taken my seat today and have thanked everyone. I don't have any words now to thank everyone, but still I say, you know, the session was quite informative, practical, interactive. That is the most important thing which we want in any webinar. And, you know, ma'am, I'm telling you seriously, today is the first webinar where I have noted down everything. I haven't used my paper in the last 40 webinars. So this is the first webinar which forced me to take a paper and a pen to write it down. I'm thankful to my entire team, Shobit, Priyanka, Zoya, Hitakshi, Komal, and we also have our technical persons who have, you know, always be there to see that there is no technical mess. And definitely, Meghna ma'am, without your presence and consent, it would not be possible. And again, Naginder, you know, you made this thing possible. We all are thankful to you. My office is thankful to you. Our series of webinar is thankful to you. Yes, Shobit, always last words from you.
Sir, I always note down all the important points in all your webinars.
I'll take a copyright of this.
Okay, sir. Okay, sir.
Okay. Thank you so much, ma'am. Thank you. Thank you for this session.
Thank you. Thank you, sir.
Thank you so much.